Thank you so much, Justice Ayubi. The fact situation, the case study that he presented implicates, there are 8 principles in the Moroccan Code of Judicial Conduct. Those principles are independence, impartiality, equality, integrity, competence, judicial conduct, decorum, and solidarity. What are the corollaries? Are there corollaries between these 8 principles in the code, the Moroccan Code of Judicial Conduct, and our code, our proposed Code of Judicial Conduct? Judge Houston will educate us on that. For instance, Principle 1, independence. What are some of the corollary principles, Judge Houston, that we might expect in the code of our canons of judicial conduct?
Testing. I believe each of you has a copy of the comparative analysis that we put together here. It's not exhaustive. Codes of conduct are flexible documents, so a number of the principles transcend into other principles. The concept of fairness and impartiality are all consumed in independence. They cross various lines. You can't pigeonhole each of the qualities mentioned by the justice. You can't pigeonhole one, separate one from another you can't talk about 1 or 2 principles without speaking about others. And so in that context, we can look to, first, we'll look to the Moroccan Code first. The first principle of independence. We've outlined some of them here for you. To help maintain the independence of the judiciary from other powers, perform duties without any extraneous influence, pressure, inducement, threat, and interference, avoid inappropriate associations with political powers, avoid situations in which one is subject to political powers' influence, and be neutral towards all parties. The Moroccan principle of independence, as you see, is discussed throughout the first 3 canons of the ABA Model Code of Judicial Conduct. The ABA Model Code of Judicial Conduct is comprised of 4 canons, 4 broad canons. Within those canons, there are rules that apply to the canon. So as you can see from the handout here, and I trust that we will have an opportunity to have this translated for our Moroccan colleagues and cousins, either during the conference or sometime thereafter. With respect to independence, the ABA Code also deals with bias or the lack of bias, lack of prejudice, and not harassment towards individuals appearing before the court. The ABA Code in Rule 2.4 informs us on external influences on judicial conduct. The same sort of principles we heard about that I just mentioned with respect to the Moroccan Code. Would you repeat the question, Judge Trump?
Was that analysis handed out?
Oh. All right. This is, my apologies. This was sent to you via email for the American colleagues. We'll, at least we'll have an opportunity, I hope we have an opportunity to share it with our Moroccan colleagues before the end of the conference or soon thereafter. To avoid influences on judicial conduct, external influences, the American Code also deals with avoiding appearances of impropriety with executive branch, with the legislative branch. While we have to work together on a number of things, we have to avoid the associations that will cause that will cause the public to feel that there's some impropriety in the way we conduct our business. We have to appear before governmental agencies as judges from time to time. We have to consult with other government officials from time to time. But in doing so, we must do so in a way to avoid an appearance of impropriety, to avoid an appearance of lack of independence, lack of impartiality, and lack of integrity in the process. Judicial officers in the United States are appointed by executive officials, the President of the United States, the governors of the various states, and sometimes other local officials. Other judges in the United States run for elections through a regular election. They campaign to run to be judges. We do not have a formal justice school, a school for judges. There are qualifications to become a judge in the United States. That is so many years of practice as a lawyer before you can pursue a career as a judge. But for the most part, we become judges through appointments by political parties, by the political executive, the President of the United States, and governors of the particular states. But even having said that, once we become judges, we must make sure that our decision-making is not aligned necessarily with the political power that appoints us. We must decide cases independently and impartially and avoid that connection that might appear to the public to create an appearance of impropriety, an appearance of unfairness, an appearance of lack of equality with respect to the parties before the court.
Yep. Judge Houston, okay. Principle 1 of the Moroccan Code says, avoid inappropriate connections with the executive and the legislative powers and should not be subject to any influence by them. Rule 3.2 of the Code of Judicial Conduct, ABA proposed code. A judge shall not appear voluntarily at a public hearing before or otherwise consult with an executive or a legislative body or official, except, and then there are certain exceptions, in connection with matters concerning the law, the legal system, or the administration of justice. So there's a direct parallel, direct corollary there. However, in the Moroccan Code, and let me throw this out to both of you, the Moroccan Code says that a judge should perform the judicial duties on the basis of the judge's assessment of the facts and careful consideration, understanding of the law, and in accordance to what is dictated by his or her conscience. Compare this with Rule 2.2 of the ABA proposed code. The duties of judicial office as prescribed by law shall take precedence over all of a judge's personal and extrajudicial activities. A judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. Rule 2.2. Now, in the comments to Rule 2.2, it says, although each judge comes to the bench with a unique background and personal philosophy, and of course, you heard this in Judge Higginbotham's letter to Clarence Thomas about bringing your values to the bench. A judge must interpret and apply the law without regard to whether the judge approves or disapproves the law in question. In Louisiana, because of the civilian methodology, we do not adhere to the concept of stare decisis. I imagine that is similar to the Moroccan methodology. But the Moroccan Code, Justice Ayubi says, you must apply the law according to the facts and in accordance to what is dictated by his or her conscience. Suppose his or her conscience does not comply with the black letter law. What does a judge do? In the United States, Judge Houston, and what does a justice do or a judge in Morocco does?
I think there are two schools of thought with respect to interpreting that provision. One is that American judges are required to follow the rule of law and apply the law to the facts. But also in America, the rule of law, there may not be a rule of law as to every situation that comes in front of you. So you have to apply the law to the facts that you have so the outcome can be different in a particular case because you've applied the facts to the law that you have in front of you. Sometimes we're called upon to make novel decisions where there is no law on point in that particular circumstance regarding the litigants in front of us. In those circumstances, we have to apply our discretion as to come up with the just and appropriate outcome in the case. And I think when we exercise our discretion in that way, we are performing in a manner, in my mind, somewhat similar to the principle laid out in your code, that you make a decision in a just and fair way, in addition to what the law in addition to or as an exception to what the law actually is or what that law actually demands. I'd like to hear your thoughts.
Yeah,
on that.
Justice Ayubi, how would you apply this under Moroccan law?
Yeah, if I can take it just on the side of the criminal law. In Morocco, in the criminal law, you have the law, you have texts, you have articles that describe the offenses. If you don't, this is the general principle. If you don't, there is no crime, no offense, no punishment. If there is no crime, if there is nothing to do in the code, you cannot, punish somebody. You apply the law to the facts. But this fact, as you say, there is no crime. It's not, noted in the code. We can say that there is no crime, that's all. But it depends. If it's the civil law, it's other thing. But in the criminal law, it's we cannot, be legislators. If there is no crime, if there is no punishment, you cannot do it. I don't know if there are others.
How much discretion is there under Moroccan law in applying, let's say, the provisions of your civil code? Are you allowed to deviate from the black letter words of that code?
I think this one of my colleagues will come here in the next.
You might want to use the microphone.
Excuse me. One of my colleagues, I think, is coming to this here, and he will be able to answer this question more than me because I worked only on the criminal law. So please keep this for my colleague who is coming next.
Yeah,
there's an element of fairness.
Excuse me, before we move on, I would like to say that I agree with the judge with respect to criminal law. My comment wasn't to the point that if a crime isn't a crime, you can make one if you think you should, because we have to follow the law. All right. My thoughts ran along the lines of in the civil practice, when you're focusing on whether or not someone's liable or not in a particular circumstance, the law gives you guideposts in order to work that through. And you have to apply the law of the facts that come before you in order to come to a decision. But sometimes the law is not clear with respect to a particular circumstance. So you have to give your best guess with respect to what the law is in that particular circumstance. And my comment was along the lines that I believe is consistent with your principle under independence, where it says that you are the judges to perform duties on the basis of the judge's assessment of the facts and a careful understanding of the law in accordance with what is dictated by his or her conscience. You know, we're elected as judges, so we're appointed as judges to also use, because of the nature and extent of our common sense and human experience, the manner in which we have developed good judgment as lawyers over the years. So sometimes we have to use that conscience, that good judgment in making a decision when the law doesn't clearly dictate what that decision should be.
There's a painting that I have in my office. There's a famous painting. It's called Conscience.
Excuse me.
That when the law is not clear, then there is precedence.
Excuse me, it's not clear. The judge should refer to the precedents. That's all.
Okay.
You have the precedents of the Supreme Court, as in Morocco, for example, or the other Supreme Courts in other countries, and especially to the French one. I think this is the solution. And my name is Abdul Razak, and I'm from the Supreme Court of Morocco. I'm judge in the Supreme Court of Morocco.
Nice. Thank you.
Excuse me, everybody. I didn't present myself for the first. Well, لا شكر على واجب.
Thank you.
We want this to be participatory. Are there any questions or any comments? Please feel free. Yes.
1 minute.
While we're waiting for the mic to be shared with a member of the audience, I'd like to just comment on the justice's comment with respect to if the law is not clear, you go to the president. That is true. In the United States, Congress, our legislature, determines what the law is. It is for Congress or the legislative branch to modify the law or change it to fit circumstances where it is. Oh, okay. You said president. That's right. Well, the judges, stare decisis is made by judges in the United States. Yes, yes. I'm sorry, my thinking was, I thought I heard you say that if the law was not clear, you go to the president. My apologies. I understand now. In the United States, if the law is not clear, Congress can create a new law, or the legislator can change the law to make it fit a certain circumstance. Judges are not to make new laws, at least on the trial level. Our appellate courts, the Supreme Court makes new law. Appellate courts make new law, but not trial judges such as myself. And also, the justice also wants us to share that if there's someone else here from a court here in Morocco that has some comments, please feel free to chime in and assist us.
Please, just, I want to take your authorization, just if it's possible, since we have translators and we have some Moroccan justices here, they can add their opinion to this discussion, but if they can intervene in Arabic, because we have translators here, can you open the floor for them?
Okay, absolutely.
I have a microphone. Does anyone want to make a comment? Tell us who you are.
Yes, yes. Good. Yes.
Go through no.
إبراهيم بولحيان محكمة النقد بالمغرب. Yes, yes, yes. Good evening for. قاعد أجيب. لا طبعا. بخصوص النقطة هذه التي تكلم عنها الأستاذ أيوبي، صحيح هي القاعدة لا عقوبة إلا بنص، لكن في المدني عندما يكون النزاع مدنيا فإن القاضي مخول أن يؤول القانون، هو نفسه من حقه أن يفسر القانون. تفسير القانون لأن القاضي لا يجوز له في الميدان المدني أن يرد القضية بدعوى أنه لا يوجد قانون. جميع النزاعات المدنية يجب أن يبت فيها القاضي لأنها نزاعات موجودة بين أشخاص، بين أطراف. إذن هناك طرف له حق وطرف عليه حق، أو الطرف المدعي ليس لديه أي حق. القاضي يجب عليه أن يبت بالقانون إذا كان موجود طبعا نص واضح. إذا كان النزاع يعني في احتمالات، القاضي يجتهد عليه أن يطبق القانون الأقرب إلى النزاع أو يؤول القانون حتى يتأتى له البت في النزاع. شكرا.
The code predominates. If a specific code article covers a course of conduct, then that code article is applied. If there is no code article, then one resorts to jurisprudence based on either habit or custom in that particular jurisdiction. Okay, correct. And of course, that is based upon, as you said, conscience. Where there is no law, there is conscience. But the code predominates. The code governs all courses of conduct and all civil interactions between individuals. Okay. Now, we started late, so we should give us a couple more minutes. Thank you. Give us until 10 to 1. Give us 15 minutes, okay? Yeah. All right. And then Justice Ayubi wants to explain in a couple of minutes the structure of the Moroccan judiciary, and I'm going to use my discretion to allow him to do that. Okay. Principle 1, we've reviewed. I think it's impossible for us to discuss. There are so many corollaries between the Moroccan Code and our ABA Code of Judicial Conduct. So what I'm going to ask Judge Houston to do is go through his comparative review and analysis, and rather than having to discuss each and every one of them, perhaps just articulate the principle under the Moroccan Code of Ethics and also articulate the corresponding code article in our Code of Judicial Conduct. You have copies of both, and you're able then to compare them. And if you don't, we are going to make sure that the email that was sent out recently, each and every one of you will get. John.
All right. Principle 2 of the Moroccan Code deals with impartiality. Performing duties without favor, bias, and prejudice, acting in a manner that maintains the confidence of the public and litigants in the judicial system. It creates rules for disqualification to ensure there's confidence within the judicial system. And it's designed to avoid creating an impression of favoritism or impartiality.
And the rule governing disqualification or recusal the rules are very similar. We have the reasonable man rule. That is, if one's impartiality might reasonably be questioned, then you should get yourself out of there. You should recuse. The Moroccan Code says, disqualify himself from hearing disputes that might raise doubts about his or her impartiality. Very, very close.
That's true. Our two codes align with one another, fairly equally throughout the entire process. When we discuss impartiality in the United States, we also deal with gift giving. Judges should not accept gifts without certain parameters, reimbursement for expenses without certain parameters. There are reporting requirements. There are requirements in dealing with political circumstances, whether you have to run for election or appointed for election, or dealing with other family members who are political candidates or political officers, and how the public perceives when a judge has a spouse or a family member who is also a member of the political community, as to what the appearance may appear to be if those situations aren't handled in a way that the public continues to have confidence in that particular system. I'd like to move on to the third principle since we're running short of time. The third principle under the Moroccan Code is equality. That is, the code emphasizes welcoming diversity, treating litigants fairly and equally, refraining from anything by words or actions which might raise doubts about one's judgment, requiring lawyers and attorneys and other persons in the courtroom to respect each other, perform duties without favor, bias, or prejudice. Canons 2 and 3 of the ABA Code reflect the same principles, avoiding bias, prejudice, and harassment, and affiliating, for example, with discriminatory organizations. There's also this issue of civility that we frame in the American context, which deals with the respect to others in the courtroom and respect to litigants in the courtroom. Our general term for it is civility in the practice of law, so that the judges respectful to all litigants, the lawyers must be respectful to opposing litigants and opposing parties, and also the courtroom staff. Those principles pretty much mirror one another with respect to equality in the courtroom. The fourth principle under the Moroccan Code is integrity. To keep oneself in behavior and appearance away from anything that may inflict damage to one's integrity, dignity, or that would malign one's integrity. The same principles apply under the ABA Code, that we have to conduct ourselves in the courtroom and in our personal lives in a manner that would not create any distrust amongst the public or any lack of, or an appearance of impropriety amongst the public. We are always on duty as judges. The public demands that we maintain our integrity and our independence and our fairness in our day-to-day lives, not only when we're at the office or when we're in the courtroom or chambers. Our rules mirror one another in that regard with respect to the appearance and behavior of a judge in work and away from work, as well as the manner in which he approaches others with respect and dignity.
John,
Yes.
Under the equality section, are there any women on the Supreme Court here in Morocco? Do you know?
Can someone, I'm not certain.
Yeah, there are so many women, and there's one behind you.
Okay.
Behind you. there are, I think, I'm not sure, I don't have statistics, but more than 30% of the presidents and the councillors are female. And not only in the Supreme Court, in all the judiciary in Morocco. And even when I was a director of the school, training, judicial training, we used to have about between 23 to 25 of the trainees are female. And the most, intelligent trainees are female.
Okay.
I have two. I have one here. I have two here. They we are proud of them.
Stand up, stand up, stand up.
Stand up,
They
stand
will
up.
be the future of Morocco. We have also the chiefs of jurisdictions in Rabat, in Casablanca, in administrative
thank
courts,
you.
in commercial courts, in primary courts, in appeal courts. We have inspectors in, there is no problem now between.
Allow me to say, the judge who asked the question is the Honorable Elizabeth Riggs from San Diego, California. She was the first African-American judge in San Diego, California, the first one.
Okay, yeah, continue, Judge Houston.
Principle 4 deals with integrity under the Moroccan Code. A judge must leave the impression of actual realization of justice, which goes beyond the actual decision of justice. This is what we discussed this is what I discussed during the evolution of the judicial code. It's the appearance. In American context, we call it the appearance of justice and the actual justice that occurs in the courtroom. Because most citizens of your country, as well as ours, probably never been in the courtroom. And so it's the appearance of what they feel or see or hear from others that makes a difference with respect to how they accept the rule of law, and which has so much power and influence on our various social fabrics in our cultural context. So it's that appearance of impropriety that, as framed in the Moroccan Code, the impression of actual realization of justice. That's what's so important to bond the public to be willing to follow the rule of law in the judgments laid down by judges in any court in the world. The integrity of the process is interwoven with the other principles we've already discussed: independence, impartiality. These principles are germane to any system of justice and any system around the world for the public to have confidence in the integrity of the process. The ABA Code reflects the same principles in a number of ways, dealing with, for example, the compensation we may obtain from outside activities, political activities, reimbursement of expenses from various non-legal groups, non-law related groups and such. The principles really mirror one another in that regard as well. The next principle is competence. Principle 5 under the Moroccan Code deals with competence. To keep up with developments in the law, actively seek to improve one's competence and efficiency, contribute to legal research, attend seminars, and give lectures, and to participate in a wide variety of activities that can enrich one's judicial experience. The ABA Code is similar. Rule 2.5 of Canon 2 of the ABA Code deals with competence, diligence, and cooperation amongst judges to further and advance the rule of law in our country as well. The big one, another very important principle that sort of embraces all of the other principles that we have discussed is judicial conduct. This is huge in the United States, as it is here, according to the canons, according to the Moroccan code as well. Judicial officers must maintain order and decorum in the courtroom, be patient, respectful, and courteous to the parties, to the lawyers, to the litigants, and to court staff, to carry out duties in an efficient, competent, and timely way, and to avoid the appearance of impropriety or bias, and make decisions based on the law and the facts, and recuse oneself if it is appropriate to do so. These same general principles apply under the ABA code regarding avoiding abuse of prestige of the office, giving precedence to the duties of the judge, avoiding external influences on judicial conduct that may call into question your independence and your integrity, the responsibility to decide cases. We have a responsibility to make decisions and to avoid ex parte communications, we call it. The word ex parte communications is not in the Moroccan code, but the concept is there. That is, not to deal with a litigant when the opposing litigant has not received notice of the hearing or the discussion. We call that ex parte communications. That is a very important aspect of conduct in our realm as well. And dealing with and avoiding inappropriate extrajudicial activities, because once again, our conduct and behavior as judges is gauged in the courthouse and outside for them to follow the rule of law or the judgments that we pronounce.
And Justice Alexander, when your local newspaper decides to write stories about your various travels, you cite to them Rule 2.1, Comment 2, Judge Alexander. We should promote public understanding and confidence in the justice system. That's a corollary to Principle 5 of the Moroccan Code. Got that? Yes.
A judge if they think that there is some partiality, like we can do in the U.S. if an attorney believes that a judge may be impartial. Is there a mechanism where an attorney can come into court and file a motion or pleading to recuse that judge from hearing that particular case due to impartiality?
Justice Ayubi, if a lawyer decides or thinks that you can't be impartial, can that lawyer file documents asking you to disqualify yourself? Yes, the answer is yes.
You know, it can be, of course, he can do this. We have two ways. It's in the procedure of the civil law, the civil procedure. There is some articles that forbid a judge to hear or participate in a case if in certain conditions, like if he has a party from the family or something like that. But also, if a lawyer sees that the judge must be, or perhaps in his understanding that the judge is not so impartial, he can ask and have this demand to the Supreme Court, to the Court of Cassation, to take the case from this tribunal to another tribunal. And you can, there are some colleagues here, they can correct me if there is something like that.
Okay. What about principles 6, 7, and 8 briefly, Judge Houston? Judicial conduct, decorum, and solidarity.
I've discussed judicial conduct. I could dwell on that we could talk about that for an hour, but I'd like to move on, if I may, to principle number 7, which deals with decorum. A judge, the Moroccan code requires a judge to maintain courtesy in all activities, respect the Chief Justice, treat everyone, I don't have my glasses on, treat everyone courteously, and ensure that personal obligations do not compromise one's dignity and impartiality, avoid the appearance and the appearance of impropriety in all activities, and to review conflict circumstances. I should put on my glasses. And to ensure no conflict exists between the judicial and non-judicial activities, and maintain order and decorum in all courtroom sessions. Canon 2 of the ABA Code also focuses on decorum. Rule 2.8 deals with decorum in the courtroom, the judge's demeanor, and communication with jurors and with others. Principle 8 deals with solidarity. This principally relates to activities between judges to support one another, to support the Judges Association and to participate in it, to avoid activities and matters that would cause harm to colleagues, to face with other judges any threat that may influence or prejudice the reputation of the judiciary or of its independence, and also to discreetly address issues amongst judges with respect to, within the association, that only judges can talk to judges about in a very discreet way. The ABA Code section, Canon 2, sections Rules 2.10 and 2.14 follow these principles. It goes on to, they talk about judges are to work with one another with respect to disability and impairment. Only a judge possibly can talk to another judge about when or whether it's about time for one to leave office, or if there's you're not performing as you should on the bench. We don't leave that entirely up to the public. We attempt to police ourselves in that regard. Judges, with respect to solidarity, should be careful about judicial statements made on pending cases and on impending matters. We should not discuss under the ABA Code a case that is before another judge and give our opinion in public with respect to the decision in that regard. Out of a matter of courtesy and civility, it's up to that judge to decide the case, and a judge who is not involved in it should not weigh in with the public as to what the decision should be. You should leave it to the judge assigned to the case.
Do you have this principle of solidarity between judges within the association? Within the association? Because it's in Morocco, I see that it's.
Okay. Well, we have, the judicial section is a judicial association. We're here as part of an association similar. We support one another. We intend to enrich the quality of our work, our jurisprudence within each other, to further the enhancement of the administration of justice. In our particular states and otherwise, we have judicial associations as well, where we meet, we confer, we have classes or seminars, judges to train with each other so that we all can learn the latest law and to understand what the law is, and to further improve the confidence of the public in what we do. So there are training sessions within judicial associations to ensure that we're all up to speed and follow current law and new developments. Judge Trapp?
But I don't believe that we have any suggestion or encouragement to be involved in judicial organizations. So I think that's a difference, and sounds like something that we should consider.
That's true. Our code does not require us to associate with a judicial organization. That is so true. It's not the black letter law of our code. Thank you, Judge. But judges do.
We have those principles of collegiality within our own body.
Yes.
And I think in Principle 8, solidarity, that principle evinces really strong support for collegiality among our various associations and colleagues.
Yes.
Yeah, perhaps that will, Judge Trapp, that is appropriate for consideration.
All right. Yes, Judge.
Excuse me. We have also in Morocco associations.
Yes.
I think we have 4 or 5, something like that, who sustain all what the justices and the magistrates do in their job.
Yes. The judge indicated that there are 4 or 5 association of judges to ensure these competencies as well. In the United States, the federal judges, for example, meet once a year amongst themselves for training. There are some judicial seminars to improve our understanding of what the current law is, and for that collegiality and solidarity as judges. In state court and state bar associations, the judges may meet separately, especially in the ethnic communities in the United States. The Hispanic lawyers, the Hispanic judges meet separately. The Pan-Asian judges meet separately. And it's not an uncommon deal for the solidarity to come together to get to know the best of one another and also to assist each other in understanding the current law so that we can be the best judges we can be. That's an overview. We don't have much time, but I'll conclude with that. To the moderator, I'll conclude with that. That's a slight, very simple comparison between Moroccan Code of Judicial Conduct and the ABA Code of Judicial Conduct. We don't have time to have an exhaustive discussion of all the various principles, but that's enough, I believe, to share with each of us that our principles are quite similar, as has been shown through time, through ancient civilizations. These notions began to develop centuries ago, and they've culminated into our various codes of conduct. Unlike other civilizations, we've enhanced them over the period of time. Those codes are flexible in nature. They have to continue to grow and evolve as circumstances within our respective jurisdictions evolve. We have to evolve and make flexible and improve our code of conduct so we can govern each other accordingly, so that we can ensure once again that the public has confidence in what we do. The public feels that it has a mandate to follow the rule of law as we present it in our judgments, because we are independent, impartial, and we present the level of integrity that they expect.
John, does the Moroccan courts have a jury system as we have, or do they do judicial decisions made by judges, or do they have?
That's a good segue into our conclusion. Justice Ayubi would like to address us briefly on the structure of the Moroccan judiciary, and that's consistent with Principle 8 solidarity, to contribute to all acts that aim to upgrade and promote the judiciary. So he is going to use this wealth of knowledge that he has to promote the judiciary and to enhance our knowledge, our collective and individual knowledge on the structure of the Moroccan judiciary. Justice Ayubi.
Thank you.
I'm sorry, I think I will do it, but just very briefly, because if you have any idea about the French judicial system, it will be easy for you to understand our judicial structure. It's very simple. We have two kinds of jurisdictions: the common law or general competence jurisdictions, and then the specialized jurisdictions. Specialized, it means the business or commercial tribunals and the administrative tribunals and courts. We have two levels, of course, the prime, not district, I think you call it the district tribunals or the prime tribunals. And then we go from the primary tribunals to, if the parties want to appeal, they appeal to the appeal courts. And then from the final decisions can be appealed to the Court of Cassation. The same for the specialized jurisdictions. But the difference is, for the common law, we have in every district, we have a tribunal district. I mean, in every district. It's about 60 or between 60 or 70 jurisdictions. And for the specialized, in the administrative, I think we have only 4 prime tribunals, and in the commercials too, we have only 4. We have, as appeal courts, I think 3 appeal courts for that specialized jurisdictions. But as cassation, all the jurisdictions, specialized or common law, they have this court of cassation for the moment. I mean, when I say common law, it means they deal with criminal, civil, and everything. The exception is the commercial and the administrative. But the crime, the serious crimes, are heard in the appeal court, not in the private court. The crimes which goes in the punishment more than 5 years, it's heard in the criminal chambers of the appeal courts. This is very simple to give you an idea, but it takes about 1 hour or 2 hours to give more details about everything. But the structure is like this. It's not more than this.
Yeah, Justice Ayubi, does your court have to accept every case that comes before it, or can you pick and choose which case you're going to hear?
Which court?
Your court, the Court of Cassation.
The Court of Cassation?
Yes.
The final decisions. I mean, if they go by the appeal court, of course, all the appeal court decisions in a certain, limit of time, they can be appealed to the Court of Cassation. And others, but some exception for other final decisions. Not, almost, it's not like you. The majority of the decisions from all the nation come to the Court of Cassation. So you will find more than 100,000 cases in the Court of Cassation, and you will find more than 200 or 150 counselor and judges in the Court of Cassation. It's not like your court, only 9 or 10. No, you have more than 150 judges in the Court of Cassation.
Judge Thibodeau,
Yeah,
what
just-
about jury?
George? The jury? We don't have no more jury. It's professional judges. And the high crimes, we used to have this before 20 or 25 years, but now only the professional judges who deal with the crimes, no jury.
Thank you all for your rapt attention. I've been given a signal that we have run out of time unless there are really pressing questions.
Did you want to take questions?
Okay, one more question, I'm told. One more question. Yes, sir.
I'm Mr. Ibrahim Zaim, Justice at the Supreme Court. I am wondering about the election of judges in America and the impartiality. I mean, the issue of political issue and what the judge can do with this election, because he is elected by citizens, so he will not be impartial in some cases. What is your precedent in your country about this issue?
About the election of judges?
Yes.
Many states elect judges at the federal level, where Judge Houston is. The judges are appointed by the president for life. But however, in the various states, many states, like my state, elect judges. Are there political influences in doing that? Yes, there are. I think a judge, in my view, has to recognize the baggage that he or she brings to the table, and has to recognize those political influences, because we're human, and we have to do our best to put them aside and apply the law as fairly and as impartially as we possibly can, as fairly as we possibly can. And there are a lot of monetary considerations, because in many states, judges, lawyers, corporations, and entities are allowed to contribute to a person's campaign for a judicial office. And there's a big debate now over the propriety of the amount of the contributions that one can lawfully contribute, and what is proper or not proper, and whether or not a system of elective judges is better than a system of appointed judges, or vice versa.
Excuse me. I want to add something to what my colleague, Mr. Ayubi, said just earlier. The common law doesn't exist in Morocco. We don't have the common law as it exists in North America. When we talk about common law, it's a translation about le droit commun from French to English. But it doesn't mean the common law which exists in North America.
Excuse me, I meant not common law as a system. I meant the general competence of the jurisdictions. That's why I didn't mean it as a judicial system in Francophone, but as a general competence of all the jurisdictions.
No, because in the United States, in Canada, they have the common law, and it is completely different than the
not common law as a methodology, but common law in the sense that it's peculiar to that area.
Now, we have all written in Morocco as our laws stems from the French law. This and since that, why? I explain. Because we were colonized by the French.
We in Louisiana comprend très bien. Yes.
Before you leave, make sure you fill out this form to, for the conference.
Yeah, Judge Cousin.
Well, I think in the United States, where we have appointments, whether federal or state, particularly state, the appointing authority generally appoints persons who agree with the who are from the same political party as the appointer.
Let's give our panel a round of applause, please. Well, as I call our esteemed chair to the podium, let me remind you to make sure that you sign in for your CLE credits and fill out these forms on the seminars as you go forward. And the luncheon will be next door starting in the next 10 minutes.
First, we'd like to thank you for your patience. Obviously, we had a CLE that went long this morning because of the discussion was interesting, and the participants were from here, Morocco, and from the U.S., and the dialogue exchange was outstanding. First, let us make sure we give our guests and our host a round of applause for the excellent job they did. You've heard me say this before, and I shall share it again as often as you see me. My name first is Emerson Thompson. I'm a senior judge from the state of Florida. I will be presiding over this ceremony today with my colleague, Judge Shauna Grave Robertson, from the great and sovereign state of Utah, where she was born and raised and skis. Here's my saying: stand up to be seen, speak up to be heard, and sit down to be loved. The program has been long. You do not need me to entertain you. Is there any member here of the Judicial Council or the ABA who does not know how to read and write? Raise your hand. NBA, National Bar Association. I'll speak louder for you. I see no hands, so the program will proceed as printed. Our purpose here today is to recognize some stellar participants on this day where we honor the memory of A. Leon Higginbotham. So at this time, I'll introduce Judge Rodney Smith of the Circuit Court of Miami-Dade, Florida, and he shall introduce our elected officials and guests. Please welcome Judge Smith.
Thank you. Good afternoon. Good afternoon. Well, I do have a confession to make. I do not know how to read and write in Arabic, so I apologize for any pronunciation that I do not call out your name. But first and foremost, we want to acknowledge this time some of our esteemed colleagues, some of our esteemed guests and elected officials for giving us your time, your talent, your love, your peace, and your friendship. So once I call your name, please stand up to be acknowledged. Salah Abdul Razak. All right. So, how did I do? Oh, here. All right.
We just want you to
We
wave.
just want you to wave so everyone can see. Thank you. We have next is Atika Sintisi. Thank you. They don't have it. He's a justice. The Justice of the Supreme Court, Mohamed bin Hamoun. Thank you. Thank you. Justice of the Supreme Court, Jalali bin Dajor. Justice of the Supreme Court, Rajat El Marahi. Justice of the Supreme Court. And last but not least, we have Brahim Buhilan, Justice of the Supreme Court. Thank you.
To the Judicial Chair, Judge Denise Langford Morris, honored guests, members and friends, on behalf of the National Bar Association, the oldest and largest bar association of African American lawyers, judges, and law students in the United States, I am honored to bring you greetings and a very, very warm good afternoon. Founded in 1925, the National Bar Association has always been dedicated to justice and achieving civil and human rights for all. We're very honored to have been invited here to continue our efforts and collaborate with the Moroccan judiciary. The big story that we're going to have between Morocco and Black America will be fabulous. I know that we're helping and assisting with the reform of 2014, but I know that that will extend to many, many more years. The National Bar Association stands ready, willing, and able to assist in any way possible. At this time, I'd like to have members of the National Bar Association Board of Governors please stand and be recognized. I'm also extremely honored to introduce to you some of our past presidents upon whose shoulders we have stood, who have traveled here to be with us today. Past President Robert Harris from Oakland, California. Past President Dr. Walter Sutton from Bentonville, Arkansas. Past President Kim Keenan from Washington, D.C. Past President Vanita Banks from Chicago, Illinois. Past President Darrell Parks from Tallahassee, Florida. And last but not least, the past president who I have spent a large portion of my life with, my husband, past President Michael Rozier from Bowie, Maryland. I don't see her, but last but not least, I want to introduce and recognize the hardest working executive director that I've ever known, Miss Alfreda Davis. Is she in the room? She's out there working.
She's working. She is hard work.
I believe that this is just the beginning of a very long-term friendship and relationship where we will be able to collaborate together. And believe me, I know that the National Bar believes that the best is still yet to come. Thank you.
As you know, the mayor gave wonderful remarks earlier, and in his absence, we thank him so much. He was called away immediately after he greeted us this morning, so he will not be with us this afternoon. So with that said, at this time, we will have our invocation, followed by a musical selection.
Good afternoon. Kindly bow with me for a word of invocation. As we come together to share in this food and fellowship with our Moroccan brother and sister judges here on African soil, let us first remember how it came to us and be grateful to the people who made it possible. This food was born from the bounty of the earth in warm sunlight, rich soil, and cool rain. May it nourish us in mind and body and provide us with the things that are good for living and necessary for service. We are grateful to those who cultivated it, those who harvested it, those who brought it to us, those who prepared it, and those who serve it to us. May its consumption bring about the pleasures of love, good company, collegiality, and friendship. And as we enjoy this food in each other's company, may we also remember that what we have in common and what brings us all together. May the sharing of food foster peace and understanding among us. May it fortify us as we seek to ensure that justice is served. May it bring us to the recognition that we depend on each other for all the good we can ever hope to receive, and that all the good we can hope to accomplish rests in helping others in turn. And finally, may it remind us that as we reach out to others to enhance their lives, so too are our lives enhanced. Amen.